My ex-husband sent a lawyer's letter claiming half ownership, attaching a printed conversation from 1992. The court deadline to respond is noon today. I've gathered 12 years of cancelled checks and tax returns, proving I paid the mortgage alone. The kitchen table is cluttered with faded checkbooks, bank statements, and frayed folders. My fingers, slow but steady, sift through 23 cancelled checks from 1998 to 2003. Each bears only my signature, a fact I underline in the motion I drafted yesterday. Adjusting my reading glasses, I mark the dates, confirming no co-signatures. At 10:38 a.m., my phone vibrates. Mark's attorney, on schedule, pushing hard, has sent an email. It contains a terse statement. Mark claims an oral agreement from 1997 granted him half the property. He attaches selectively quoted tax returns from those years, highlighting joint filings. The lawyer's tone is clipped. The court must consider this a defense. I pause. The so-called oral agreement is unsubstantiated, yet the timeline precedes every document I have. It's a slick countermove, muddying waters and threatening prolonged conflict. I open my laptop, access the court's electronic filing portal, and start drafting a motion to dismiss the claim. Each keystroke tightens the argument. The statute of frauds demands written contracts for property interests, and Mark's only proof is a conversation snippet. The clock ticks steadily, a relentless metronome. 21 days until the hearing. Losing time diminishes chances. I glance at my wristwatch. 11 minutes pass in silence, broken only by the low hum of the refrigerator and a faint scent of brewing coffee. I set the papers aside. Outside the window, a familiar sedan pulls into the driveway. My heart steadies as I watch the man step out. Mark. 15 years ago, he vanished without warning. Now he's on my porch. His arrival wasn't noted in any legal filing. No lawyer's note mentioned it. The surprise unsettles the calm I've struggled to maintain. I rise carefully, muscles reluctant but obedient, and go to the door. Mark meets my gaze, eyes hardened by years. No greeting, just a curt nod. No warnings, I say. No calls, just show up. He shrugs. I'm here to talk, not fight. I study him. This isn't the man who walked away all those years ago. There's resolve now, but beneath it, calculation. Back inside, my hands tremble slightly as I lock the door. Mark's claim escalates. His presence complicates everything. I return to the table, call up the motion files, and open the draft. My attorney's briefing echoes in my mind. To challenge an oral agreement, I must expose gaps and inconsistencies quickly, or the court might accept joint ownership. As noon approaches, I finalize the motion to dismiss and prepare to submit it electronically. Each attachment, cancelled checks, tax returns, handwritten notes, aims to seal the case tightly. The court's countdown looms. Mark's lawyer will respond. Mark's unexpected appearance raises new threats, and the fragile peace shatters. One thing remains certain. Surrender is not an option. The county courthouse archives smelled of dust and aging paper. Metal filing cabinets lined the dim aisle, each drawer labelled with years and names. I pressed my fingers to the cold steel handle labelled 1998 tax returns. At 72, standing an hour made my back stiffen painfully with every stretch. My grey hair was pulled into a tight bun, and my glasses perched low on my nose to focus on the tiny print. I flipped through files that required 3 separate requests. Bureaucracy demanded online forms, but the courthouse Wi-Fi was painfully slow, struggling to submit my claim. 10 minutes dragged by before the clerk appeared. Thin, brisk, her heels clicking sharply on the linoleum floor. You're here for Reynolds's returns? She asked without looking up. Yes, I said. Urgent. The court hearing is in 3 weeks. I need to verify if he claimed the first-time homebuyer credit in 1998. It contradicts his deposition. She nodded, typing with clipped keystrokes into her terminal. Requests take 5 business days, sometimes longer. IRS records are federal. We only have copies filed here. State policies restrict retrieval unless subpoenaed. I tightened my lips as tension seethed in my shoulders. I'm the sole owner of the property. His claim hinges on an oral agreement from '97. But if he took that credit, it clashes with no ownership then. Local policy, she said, requires escalation through courthouse legal aid. You can request expedited review, but there's no guarantee. My heart sank, despite my calm exterior. I couldn't waste more time. Mark's deposition last week was a calculated move. I never claimed any tax benefits connected to the property, he said, voice steady, eyes locked on his attorney. A nuisance prickled at the edges of my vision, a headache forming behind my glasses. My fingers trembled while filling out the appeal. Every incomplete sentence meant delay. The courthouse clock ticked relentlessly toward noon, 2 days lost since confirming the motion draft. My limited mobility made repeated trips exhausting. Then the clerk slid a faded manila envelope across the desk. Wait, these copies arrived this morning from the IRS abroad request. Mark T. Reynolds claimed a $6,000 first-time homebuyer credit on his 1998 federal return. I exhaled sharply. The contradiction was stark. How could he deny it under oath if IRS documents proved otherwise? Her voice sounded again. His wife contacted this office last week, through her attorney, providing a brief statement denying any such credits. They married in 2000. But these records tell a different story. I folded the papers carefully, their worn edges threatening to tear. My breath steadied as relief mingled with urgency. This evidence could dismantle his testimony and strengthen my motion to dismiss his claim. Outside the archive window, a grey sky pressed down, threatening rain. I knew Mark's counsel was adapting his story daily, but for once I had something concrete and indisputable. Slowing my movements, I packed the files with deliberate care. The courthouse's flickering fluorescent lights mirrored the steady tick of the hearing clock. Time was a resource I could not afford to lose again. On the elevator ride down, my phone beeped, a message from Mark's wife. "Review your facts carefully," it read. "We're prepared for court." I looked away, steadying my grip on the documents, and on my resolve. I would use every page, every signature, every number. This time, the truth was on my side. The cramped conference room smelled sharply of worn carpet and industrial cleaner. I sat with my attorney Marla as the clock ticked toward the court's noon deadline in 3 weeks. Marla spread out 12 years of cancelled checks and tax returns on the table. Mark's team submitted affidavits from neighbours claiming he discussed joint ownership with them, but none mention mortgage payments, she said. I traced my finger along the edges of the envelopes I'd saved, letters from the mortgage company addressed solely to me during every payment period. I never told anyone about the payments. That's private. Marla nodded. We will submit a motion to dismiss, focusing on documented payments. Mark's oral claim depends on hearsay from those affidavits. We expose their lack of credible evidence. Their timeline conflicts with the payment records. The tension grew as Marla highlighted the opposing lawyers' legal maneuvers designed to delay the case. They're filing procedural objections to eat up our time and inflate my fees. I tightened my grip on the worn armrest. My knuckles turned white. Retirement means fixed income. Every dollar counts now. Keep your focus on what matters, Marla said. The court is strict about the statute of frauds. No oral contracts for property division. We have the mortgage checks, tax returns, and correspondence. That's tangible proof. I flipped through notes I'd compiled from our last hearing. Mark had returned unexpectedly after 15 years, claiming half ownership based on an alleged 1997 oral agreement. Yet his own 1998 IRS filing directly contradicted his deposition. He'd claimed a first-time homebuyer credit I had uncovered. He lied under oath, I whispered. His wife's legal advisor dismissed the credit's relevance, but official records say otherwise, Marla added. Her voice remained steady, but her eyes showed concern. Each day brought new fees, new stress. My back ached with every careful movement, a reminder of physical limits I could not ignore. Marla pulled up the neighbor's affidavits again. Look, none mention the mortgage payment schedule, nor the letters you received. They conflate ownership talks with actual proof. Their statements lack foundation. I leaned forward, adjusting my glasses. I didn't know these neighbors, or any of our acquaintances, were involved. Mark must have relied on casual conversations to bolster his story. Exactly, Marla said. Their hearsay has holes. We'll file a motion to dismiss based on those inconsistencies and the statute of frauds, but we need to act fast before the procedural delays accumulate. I nodded, feeling the weight of the looming court date. My attorney had requested expedited review from the clerk's office for the tax and mortgage documents. The pile of my carefully preserved files now fought against the stacks of affidavits filed by Mark's side. Proof versus assertion. 3 weeks, Marla reminded me. After that, the hearing starts. Your clear record and evidence are our strongest weapons. I folded my hands. I won't surrender my home to half-truths and voices with no facts. It's all here. She printed the final draft of the dismissal motion. I scanned it carefully. The legal language precise, the facts unambiguous. Let's file this electronically today. As we gathered our papers, my phone buzzed softly against the table. A message from Mark's wife. A warning to drop the case or face consequences. I set the phone aside. I could not risk my home or my dignity. Outside the window, grey clouds pressed heavily on the city skyline. The neighbours' affidavits hesitated on shaky ground, unable to account for the solid proof I held. I tightened my grip on my reading glasses. This motion would focus the court's attention where it belonged, on 12 years of undisputed payments, not elusive conversations. The micro-twist crystallized in my mind. The neighbours, pulled into Mark's claim, were unaware of the critical payment details. Their affidavits introduced a false trail. I would use that disparity to dismantle his claim entirely. The battle lines settled. Proof against hearsay. Documented payments against whispered promises. I was ready to face the coming legal storm. The courtroom smelled faintly of polished wood and cold linoleum under the harsh fluorescent lights. 10 rows of rigid chairs separated me from Mark T. Reynolds, his face hard set. At 68, my grey hair pulled tight in a bun, glasses perched low on my nose, and fingers trembling from hours of preparation, I settled into the hard seat beside Marla. 21 days remained before the judge's ruling. The moment was here. Marla handed me a stack of documents, 12 years' worth of cancelled checks, IRS transcripts, and correspondence, all proving I alone paid the mortgage. Mark's affidavits from neighbours claimed a decades-old oral agreement for shared ownership, but none mentioned payments. Their memories were twisted by time and self-interest. The statute of frauds barred oral contracts like this. My case should be airtight. Mark leaned forward when the judge called the hearing to order. Your Honor, the agreement stands. My client never claimed the first-time homebuyer credit, he said evenly. His calm hid tension beneath. The judge shifted, scanning papers. Mr. Reynolds, your 1998 federal tax returns indicate a claim for a first-time homebuyer credit. Can you explain this under oath? Mark's jaw tightened. He glanced away. That must be an error, he replied steadily. The judge's gaze sharpened. A clerical error? IRS records confirm the credit. Please clarify. Mark swallowed. A bead of sweat appeared despite the courtroom chill. His hands fidgeted with the affidavit. He faltered, caught between legal defense and the burden of evidence. Marla whispered, this inconsistency could unravel his entire claim. The judge pressed, Mr. Reynolds, did you or did you not claim this credit? I did not intend to mislead, Mark said, voice clipped. My wife advised me differently. His wife's written denial had come before, brief and detached, lacking evidence. Mark's hesitation betrayed more than she could. The judge's questions penetrated, exposing contradictions words alone could not mask. Across the room, Mark's posture stiffened. His confident barrier cracked. The judge's scrutiny demanded truth, uprooting carefully constructed defenses. I felt a flicker of relief despite the emotional toll. My chest tightened from days of worry and physical strain. My trembling fingers gripped my laptop tightly as Marla prepared to capitalize on this opening. Ms. Mitchell, the judge turned to me. Your documentation is thorough. The court notes discrepancies in the opposing claim. This hearing will continue until all evidence is weighed. Mark's lawyer tried deflecting, requesting procedural delays. Marla responded firmly, pressing for an expedited review. The tension thickened as the courtroom clock ticked steadily toward the ruling. Outside the sterile air and legal posturing, I fought rising exhaustion. My wristwatch's second hand clicked steadily, a reminder of the relentless deadline. I focused on the concrete, the documents I'd gathered, the clear contradictions Mark now could not explain. Before the session ended, the judge ordered Mark's complete disclosure under oath of all financial claims tied to the property. This shifted the battle, forcing Mark to confront falsehoods openly. The micro-twist struck hard. Court pressure revealed vulnerabilities, turning the courtroom into an arena where truth edged closer. As the judge recessed, Mark's eyes flickered uneasily. His forceful defense began to crumble. I sat straighter, steady despite the strain. Every legal document and cancelled check was a brick in the fortress I was building against his claim. The fight was far from over, but today the balance tipped. I knew I had to conserve strength for the days ahead. Yet beneath the fatigue, a quiet resolve grew to preserve my home's sole legal ownership without surrender. The courthouse reading room was silent except for the steady tapping of the clerk's keyboard. The clock on the wall read 9:02 a.m., just 2 hours left to submit new evidence. I adjusted my glasses, feeling the coarse texture of the affidavit Marla had given me the night before as I unfolded it. My grey hair was pinned tightly, but a faint tremor ran through my fingers while I scanned the statements from Mark's current wife. She admitted speaking to a lawyer, an admission that sharply contradicted previous denials I had gathered. Marla sat beside me, her eyes meticulously reviewing documents. This affidavit could break Mark's claim, she said quietly. She holds tax returns and bank statements that contradict his story about an oral agreement. I focused on a paragraph where the wife declared she had no knowledge of any shared mortgage payments despite living in the house for years. directly opposing Mark's version. Minutes later, Mark entered with a determined look. His eyes locked on me briefly before shifting to Marla. He slammed a folder onto the table. "Objection," he said sharply. "This affidavit is hearsay and should be rejected." The clerk reminded. "Judge allowed only 2 hours for new submissions." Mark's lips pressed tightly together. I noticed tension in his posture, an unspoken admission that the affidavit posed a serious threat. Marla responded calmly. "This is based on her first-hand knowledge, supported by documents. The court must consider it." Mark's expression darkened. A slight twitch at his jaw betrayed his strain. When the hearing began, the courtroom felt colder. The polished wood reflected the harsh fluorescent lights above. I sat upright, fingers folded tightly in my lap, stiff from years of paperwork. The judge shuffled through papers, then addressed Mark directly. "Your 1998 tax returns show you claimed a first-time homebuyer credit. That contradicts your claim of sole ownership." Mark's usual composure faltered briefly. Mark's wife was then called to swear the affidavit. Her voice was steady but guarded as she admitted, "I consulted a lawyer before submitting this." A murmur rippled through the room. Mark glanced sharply at her. Their united front was fraying. Marla seized the moment. "Your Honour, this new testimony disproves the alleged oral agreement on shared ownership." Mark's lawyer attempted to discredit the affidavit, alleging coaching and unreliable memory. The judge paused. "The court will admit the affidavit, but requests full disclosure of all related documents from both parties by the next session." The timer on my wrist ticked. 21 days remained until the final hearing. I caught Marla's eye, and she nodded, already calculating our next moves. The weight in my chest tightened, not from victory, but from the personal cost. Mark's wife wasn't just a witness. She was part of a fractured alliance. I felt the sting of betrayal sharper than any courtroom blow. She had chosen a side independently. As the session ended, Mark's defense showed cracks of doubt. His tight facade was fraying as we packed documents. The battle to prove sole ownership had shifted beyond legal maneuvers. It was now a personal unraveling. I adjusted my glasses again and steadied my breath. My home depended on holding firm. The public records office smelled of linoleum and harsh fluorescent light. I sat behind the glass partition, the clerk handing me copies stamped "official" alongside a typed court docket page. 12 days until the next hearing, 9 fewer than before. The judge had moved the date forward, stepping up the pressure. Mark's lawyer objected to the acceleration, citing due process concerns. But the judge was unmoved. Sanctions loomed over Mark for any false testimony. The clerk mentioned a recent order requiring full disclosure of all documents by both parties 7 days before the hearing. The timeline was now a sprint. I sifted through the recently uploaded documents. Mark's 1998 tax returns, revealing he claimed the first-time homebuyer credit, the very credit he had denied under oath. His current wife's affidavit was also among the files, admitting she had consulted a lawyer but providing no proof of shared ownership. Instead, her statements exposed contradictions in Mark's claims. Marla sat beside me, her fingers tapping a steady rhythm on her files. "We can press the timing," she said. "The judge wants to clamp down on delays. Any further requests from Mark's side will work against him." At the last hearing, the judge warned Mark directly. "Inconsistencies in your testimony may result in sanctions." Mark's face tightened, his eyes cold but guarded. He refused to admit error on record. Now, with no new evidence from Mark's side, the court docket showed only motions to postpone. each denied or ignored. The judge's warning echoed in my mind. Full and truthful disclosure is mandatory. Mark was running out of road. I opened my laptop and pulled up scanned bank statements and 12 years of cancelled checks, my payments alone. I highlighted them for Marla. They can't dispute this with oral claims. Marla nodded, eyes narrowing over the numerical trail. This squeezes them. Without tangible proof, Mark has to fold or face penalties. I glanced at the docket again. The judge's strict schedule mandated responses within 2 days. If Mark missed the deadline or tried to withhold information, sanctions could include default judgment or monetary fines. The facts were clear. Mark's lawyer tried to negotiate a softer timetable, citing health issues, but the judge dismissed those pleas. Court efficiency was the priority. Tension snapped as the clerk announced a correction. The hearing date had been moved 6 days closer than initially stated. The new deadline gave Mark fewer than 3 days to submit evidence. No excuses accepted. I felt the strain coil in my shoulders, but forced calm. This compressed time frame could break Mark's defense, or mine if I faltered. Marla read aloud from the legal code. A false statement at this stage risks contempt of court. The judge won't hesitate to impose sanctions. I stretched my fingers over the keyboard, preparing my response affidavit to file within hours. Every document, every financial record meticulously cross-checked. Mark's silence was now part of the story. No new claims, no counterproof. The pressure was undeniable. The court was stripping away any room for maneuver. Either Mark complied or risked perjury charges. I retucked my glasses and traced the lines of my own documents again. The coming week would define everything. My home, my security, the years of solitary mortgage payments. No room remained for error. The judge's tightened schedule and sharp warnings ensured that. Mark Reynolds would have to fold or face consequences. The court's tightening grip had changed the game. The hearing took place in a cramped conference room in the law library wing. A whiteboard displayed Day 5, 9:15 a.m., its ticking clock marking each unforgiving second. I adjusted my glasses on the bridge of my nose and folded the stack of documents next to my laptop. My fingers trembled slightly, though my hands remained steady. I wore a simple blouse, my grey hair pulled into its usual tight bun. Marla sat beside me, her eyes scanning the opposing counsel's files with quiet intensity. Mark Reynolds entered, his face drawn and jaw clenched, carrying a thick folder. His steps were stiff with tension, the casual jacket failing to conceal the strain in his body language. The judge was already seated, reviewing papers with a furrowed brow. Mark began by denying his earlier statements. There was no oral agreement, he stated sharply, his eyes flicking to the tax returns from 1998 he had handed over minutes before. I filed those tax returns independently and claimed the homebuyer credit as an individual. He paused and glanced at the judge before adding, My wife's affidavit only confirms consultation with legal counsel, not shared ownership. The judge shifted in his seat, his tone firm, yet controlled. Mr. Reynolds, this contradicts your prior sworn testimony. Marla leaned forward. Your Honour, the tax returns reveal a clear contradiction. The claimant's motion to dismiss is supported by 12 years of mortgage payments, cancelled checks, and these filings. She held up a printout of my affidavit alongside a spreadsheet tracking each monthly payment I made. Mark's lawyer objected, accusing us of cherry-picking documents out of context. The judge cut him off sharply. I've reviewed all submissions. Inconsistencies like these could be construed as perjury. His gaze locked onto Mark. Tension thickened the air. Mark's face paled, but he refused to relent, claiming he had misunderstood the tax credits and that his wife's affidavit was taken out of context. Marla's cross-examination was swift, exposing further contradictions between his statements and his documentation. Each rebuttal pushed Mark further onto the defensive. After 2 hours, Mark's resolve finally broke. The judge interrupted to announce sanctions. "Mr. Reynolds, your repeated contradictions and failure to disclose documents timely have compromised your credibility. This court imposes fines and will consider default judgment should this conduct continue." Mark's lawyer protested procedural unfairness, but the judge dismissed the motion. My exhaustion felt like heavy bricks pressing on my chest, yet the emotional strain only tightened my jaw. I kept my eyes on the judge, silent and resolute. The final motion to dismiss was called. Marla presented the compiled evidence with clinical precision. Silence enveloped the room, except for the judge's voice. "The motion is granted. All claims by Mr. Reynolds to shared ownership are dismissed." Mark slumped back. The brief legal advantage he had wielded was now powerless. The judge concluded, "Let this serve as a warning against further misrepresentation." The gavel struck. Final. Outside, the corridor smelled faintly of old paper and polished wood. My legs ached from sitting too long, and I touched my wristwatch, noting the exact time. A new timetable had been set to complete the deed transfer within 21 days. I gathered my papers slowly, exhaustion weighing on me, but steady with the certainty that I had preserved sole ownership without surrender. The fight had escalated, but this turn crushed Mark's claim entirely. Marla placed a hand on my arm. "He won't concede easily," she said. I nodded quietly, but firmly. The battle was far from over, but the truth had cut through the noise. The courtroom had spoken. I arrived at Mark's house on the 5th day after the court's sanctions were announced. The mailbox hung crooked, and the peeling paint on the doorframe scraped faintly against the wind. I tightened my grip on my purse, fingers trembling despite the crisp, mid-morning air. My grey hair was pulled into a tight bun. The stiffness in my spine reminded me to move carefully. Before I could knock, the door opened. Mark's wife stood there, rigid, her eyes sharp beneath a faint line of fatigue. She didn't invite me in. "You should know," she said immediately, voice clipped. "Mark isn't coming back. Not after what the court said." Her tone left no room for argument. She held a stack of folded papers close, knuckles white. I studied her face, a mask of controlled detachment. No warmth, no regret. Only cold clarity, like someone guarding a fragile claim. "I came to understand the aftermath," I said, lowering my reading glasses. My voice was steady, careful not to provoke hostility. "The court record was read aloud, yes? How did he respond?" She shifted her weight, but didn't move aside. "He's silent. Lost a lot. Not just the case. His pride, his footing." Her eyes flicked to the driveway where a rusted old sedan sat empty. I advised him. Told him to prepare for the worst. This fight, it's over for him. Her words landed like a verdict. The silence stretched. I glanced down at the papers spilling from her hands. Affidavits, legal advice summaries, and the damning 1998 tax returns where Mark claimed the first-time homebuyer credit. The contradiction with his sworn denial was clear, intentional, almost certainly. "You understand the court's deadline," I said. "The deed transfer must conclude in 21 days. No room for delay." She nodded sideways. Mark tried last-minute motions, but the judge shut him down hard. Perjury charges, fines, loss of credibility. The legal wheels move fast now. Her voice softened slightly, almost regretfully. It's over. A sharp knock interrupted us. A courier handed me a sealed envelope, court documents marked Final Order. I opened it carefully. The judge's ruling was clear. All claims from Mark dismissed. Sole ownership granted to me. The sanctions' weight hung heavy. Mark's wife watched me, her expression unreadable. He wanted to fight for a share. You won't get a second chance. He knows it's finished. I swallowed the lump rising in my throat, focusing on the cold facts. 12 years of cancelled checks, mortgage statements, my affidavit supported with precision, all vindicated. Does he have any resources left to appeal? I asked, masking weariness behind deliberate inquiry. She shook her head. Nothing substantial. His isolation has begun. No friends willing to risk association. His wife, me, will see this through. Alone. The gravity settled. Mark's legal and personal ruin had started here, in this quiet, closed-off house. His estrangement sealed. I adjusted my glasses, steadying my breath. Each move would be measured, not just to take the next steps, but to preserve everything I'd fought for. Time was short, the burden heavy, but the outcome clear. Mark would not return. I must ensure the deed transfer concludes without error or compromise. Stepping back toward my car, the morning sun cast a pale light over the cracked sidewalk, the faint smell of damp concrete rising with the breeze. The home I claimed was mine. The fight had exacted its toll, from all sides. The clock was ticking. The court's deadline loomed. No more room for doubt. The county recorder's office lobby smelled faintly of old paper and cleaning solution, colder than I'd expected. The digital clock blinked 8:42 a.m. I eased onto a hard bench, careful to straighten despite tightness cutting through my spine. My glasses rested low on my nose, fingers trembling slightly as I flipped open a worn folder holding the official deed documents. Mark Reynolds hadn't shown. His absence gnawed more than any courtroom showdown. The judge had reprimanded him last week for withholding records and misleading statements. Yet here I sat, still waiting, 24 hours before the final deadline to confirm ownership. I scanned the deed again. The county seal clear, only my name listed, no trace of Mark's claim. 12 years of cancelled mortgage checks, tax returns from 2003 to 2015, everyone meticulously prepared by Marla, who warned me no detail could be overlooked. Your presence confirms you'll follow through today, the clerk said, without looking up, sliding a clipboard toward me. I nodded, wincing as the movement sent a sharp ache through my lower back. Minutes stretched endlessly. I filled out the final affirmation forms, each signature deliberate. The clerk processed verification, tapping rhythmically. I watched a small window showing deed status updates. No new filings from Mark, no contradictory claims. The 21-day transfer deadline loomed closer. Suddenly, the clerk's phone buzzed. She glanced at the screen, then said flatly, Judge Harmon's chambers. The appeal from Mr. Reynolds was dismissed earlier today for lack of evidence. I blinked. Mark had filed last-minute motions, threatened a final oral argument, but nothing materialized. His failure to produce documents sealed his fate. The court's sanctions, the fine, the perjury warning, all had cornered him. The weight in my chest eased, though my back protested every breath. Mark's silence meant no renewed legal pressure. The house belonged to me, uncontested, a quiet resolution after months of strain. I closed my folder and stood, muscles stiff, but resolve firm. The receptionist handed me a stamped copy of the dismissal order. I tucked it into my bag alongside the deed. The office emptied as I moved toward the exit. I fought the fatigue gnawing at my limbs, focusing on the concrete fact. No appeal remained. My ownership was final. Outside, the early morning sun bounced off the cold pavement. I adjusted my glasses and inhaled deeply, the crisp air filling my lungs. I had protected what was mine without yielding to false claims. Nothing else mattered. The hardest part was behind me. Mark's silence confirmed the fight was over. Twilight settled as I stepped onto my porch, the wood boards cold and rough beneath my feet. The worn paint flaked where my trembling fingers rested on the railing. I held Mark's final letter, folded neatly, its typed apology strange after months of battle. The envelope bore no return address. I adjusted my glasses, reading slowly. I regret the claims I made. I hope we can find peace. Inside, the last court documents printed at dawn lay on the table. Sole ownership granted, Mark's appeals dismissed. The soft click of the front gate sounded behind me. My knees ached, and I leaned against the doorframe, deliberate despite the discomfort. Memories surfaced. Years of silence, strained calls, legal maneuvers. 5 days ago, Mark's wife had been clear. Mark would not return. She showed me affidavits, 1998 tax returns disproving his claim, and a brief legal note she'd secured. Mark's options were exhausted, his motions rejected. The court sanctioned him for perjury, sealing his isolation. I reread the letter again. No admission of fault, no offer but the faintest hint of remorse, fragile, almost tactical. I weighed the cost of reply. Words could unravel this fragile peace or ignite new disputes. My resources were stretched, limited savings, fragile health, and the court's 21-day deadline to a firm ownership official. Time for error had passed. The door creaked as I entered the house, the dim light casting shadows on cancelled checks and tax records neatly stacked on my kitchen table. I touched the worn edges of documents chronicling a decade of mortgage payments, each mark a silent witness to my claim. Marla had insisted on their organization. Evenings spent cataloguing, all proof against falsehood. Behind the window, streetlights flickered on with a faint hum. I sat down, my back aching from long hours bent over paperwork. My breathing steady, voice calm in my mind. The letter lay beside me like a fragile truce. Mark had no legal ground left, no financial leverage. His wife's testimony was final. I realized the letter wasn't surrender, but a maneuver to shift the narrative, to test my response. Yet without court power, his influence had vanished. I made my choice. Silence. No reply, no settlement offer. Fighting further risked exhaustion, with no peace guaranteed. The emotional wounds from years of estrangement would not ease through words. Quiet would guard what was mine without surrender to thin remorse or false claims. As darkness deepened, I prepared copies of final deeds and dismissal orders for the county recorder, a necessary step before the deadline. Each signature, each stamp, a brick in this fragile fortress. The last page bore the judge's ruling. Claims of Mark T. Reynolds dismissed. Sanctions for perjury imposed. Official separation from ownership sealed. I folded the letter carefully, securing it in the legal folder with all court orders. My wristwatch ticked steadily, marking time's final measure. My resolve hardened despite weariness. The house was mine by law and fact. Tomorrow would bring the county clerk's verification, the last checkpoint against resurgence. Tonight, I rested in certainty tempered by lingering doubt, knowing my silence was my strongest argument in this fracture born of both law and broken trust. The morning light spilled softly into the front room, the wooden floor cool beneath my house slippers. 21 days remained before the court's deadline, and my fingers trembled as I arranged a dozen cancelled checks and neat stacks of tax returns, each document a thread woven carefully into my claim's fabric. My grey hair was pulled tight into a bun, reading glasses balanced low on my nose. Sleep had eluded me. My back throbbed, a reminder of the toll this drawn-out battle exacted. The pressure was both physical and legal. Mark's last move came yesterday, a lawyer's letter asserting half ownership, citing a conversation from 3 decades ago. Along with it, tax returns from 1998 were submitted, trying to cast doubt on my sole payment record. His wife sent affidavits denying the claim, and a brief legal note disputing the oral agreement Mark insisted upon. I said nothing. Silence was the wisest counsel. By noon, I sat across from Marla at the oak table, documents spread before us. She adjusted her glasses. The court dismissed Mark's final appeal, lack of evidence, plus sanctions for perjury. I nodded, steady despite the ache. His absence during key proceedings weakened his position. "Your Honour confirmed your sole ownership," she said, sliding the stamped dismissal toward me. The county clerk had verified it hours earlier, final and unassailable. Ownership was mine without question. Now my home felt transformed. No longer mere property, but a restored fortress. Exhaustion gnawed at my joints, the stress of disputing false claims, painstakingly copying documents, submitting affidavits, and ensuring every form was flawless, had drained me. Still, I moved deliberately, folding the final deeds with care. Mark's disappearance, both legal and physical, offered no relief beyond the court order. His wife's affidavits shattered the fragile remnants of any alliance. Outside, pale winter sunlight seeped through the curtains, bathing the room in quiet calm. The tension that had lived here dissolved. Mobility limited, I rose slowly and steadied myself on the armrest. My wristwatch ticked each deliberate second, marking the approach of closure. I reflected on this documented struggle. Months of evidence, hearings, and counterclaims. The court record was closed, the legal risk extinguished. The judge's ruling had rejected Mark's claims and imposed sanctions for his falsehoods. His attempts to reclaim ownership dissolved under scrutiny, leaving me uncontested. Though weariness pressed upon me, my resolve held firm. This house carried years of memories and independence. Its sole ownership had weathered both legal storms and personal betrayals. I filed the dismissal copies away, locking them alongside mortgage papers. An unopened letter lay on my desk. Mark's faint regret, penned after successive failures. I tucked it aside without reading. Words now bore no weight. Facts held the final truth. The court had spoken. At last, the house embraced me quietly. Outside, dawn broke without fanfare, only a steady, unyielding peace. This was the turning point. I reclaimed my home, not through triumph, but through careful endurance. The final twist settled. Mark sanctioned for perjury, his wife's affidavits exposing his deceit, and a judge's decree cementing sole ownership. No further claim would arise. I closed my laptop and folded my hands in my lap. The legal battle was over. My home was mine alone.